We'll hear from the appellant when you're ready.
Got glasses. Show my age already. Your Honors, may it please the court. My name's Laura Hash.
Would you pull the microphone down a little bit?
For my short self, I sure will.
Yeah, that'll
Is that
be
better?
fine. That'll work better. Thank you.
Okay, good. My name's Laura Hash. I represent the husband in this matter. This is an appeal from the Claiborne County Circuit Court from a divorce ruling. So just a brief on the facts. It's a divorce.
Counsel, you want to reserve any time for rebuttal?
Oh, yes, Your Honor, please. May I reserve 3 minutes for rebuttal?
3 minutes for rebuttal. That'll
Thank
be fine.
you. I appreciate the reminder. It's a divorce case between two professionals with one minor child. Husband's a pilot, wife worked with an engineering group, and the parties resided together in a marital home in New Tazewell until shortly after the divorce was filed, in which the wife moved to Morristown, about 45 miles away. The parties had previously lived in Morristown and then moved to New Tazewell together, lived there. While there, wife obtained a job in Morristown. And then once the husband filed divorce, wife moved to Morristown while husband was away at work. And when he returned home to find her and the child, all moved to Morristown. Shortly after moving to Morristown, over the course of time being there, wife made a series of unilateral decisions immersing herself into the Morristown community. She has the child enrolled in daycare, in which she requires the father to bring the child to from New Tazewell every time he has her. The mother puts the child in kindergarten there, enrolls her in extracurricular activities there. She makes it such that if the father's going to see this child, he has to go to Morristown to see this child, or at least in some way have significant travel to make it happen. Nevertheless, father does that throughout the pendency of this case, which was about 2 years. Father is a commercial pilot. He has a non-traditional schedule that allows him to work 2 weeks, or requires him to work 2 weeks, but it gives him the privilege of having 2 weeks off in these alternating segments. It also has liberal amounts of time off in addition to that, and some leave because of his seniority. He's employed in this capacity throughout the entire life of the child. So while they were together, this was his job. This is what he did. This is not a brand new job that somehow impacts something different within the family. Then, while that was the case when they were married, when he was away, mom was the primary caregiver. When he was home, which was somewhat either 50% or more of the time, he was the primary caregiver for the child in the home. And so it was the way of the life that they would do that, and it did alternate in times because of his schedule. When the wife moved, everything changed. So now, if he's going to see this child, now he has to go to Morristown, and if he can't get there, well, he doesn't get the time. Her choice to leave the area where the parties resided was her.
See the child?
Not unless it's a time in which she says he can, or if there's an activity he has to get the child to, or if it's daycare, even though he's home all day, he has to take the child there per the court orders.
But the judge did grant him certain periods of time for visitation.
He did, yes, and they would collaborate to make that work so that they could either meet in the middle or transport with the receiving party picking up. I'm not saying he was precluded entirely from seeing the child. It was that his time was disproportionate. In previous times, it had been very equitable, but because wife moves, now his time is very inequitable, or it has this significant transportation issue where he has to go to Morristown to make it happen. And so the emphasis from the court was inordinately about the husband's employment, that it was his employment, his schedule that created all of these impediments to having equal co-parenting time, when reality is it was the geography that wife created when she moved that was the real impediment.
Counsel, let me ask you about that.
Yes.
If she were still living where your client lives,
Yes.
And he's gone, and there's a divorce, so she's still obviously not going to be living in that house.
Correct.
And there's divorce happens, and if your client has the child, who takes care of the child for the 2 weeks your client is off doing his job? Nobody's faulting him for doing the job, but it's a fact that he's gone for 2 weeks at a time.
Correct.
Who takes care of the child?
So my client proposed that it would be just as when they resided together, that the wife would take care of the child when he's away. And same as they'd had a schedule where it was a minimum of 12 days, minimum of 10 days, maximum of 15, that they would have this co-parenting time that would still roughly be equal, but it's contingent on his schedule, and there's just no getting around his schedule.
So it would have to change, though, so the parenting time when she would have the child would be dependent upon his work schedule.
It would be, yes, Your Honor. And it's just the nature of the schedule, the same as it would
I
be for a
understand.
physician
Yeah,
or.
Again, nobody's faulting him for his job.
Yeah.
But it's a reality.
It is a reality. I mean, and that reality is, it happens a lot.
Well, what did he testify to that he what would do as far as taking care of the child while he's working?
That he would procure a sitter if necessary, but his proposal was that it would be wife. He wanted her to have maximum co-parenting time. He wanted her to have that 50% if he couldn't do it. He wanted what she doesn't want. She doesn't want him to have that 50%.
Excuse me, did he testify that he'd hire a nanny?
He did. And that he would find someone to do that. And because he's not from here, he would likely have hired someone to do that. But she also was hiring someone to provide childcare while she was working in times in which he was available to be with the child.
How old is the child?
The child at the time of the trial was 6. I think she might be 7 or 8 now. I'm not 100% sure.
Was 6?
Not now, but at trial she was.
At time of trial, yeah.
Yes.
So,
And she just started kindergarten.
Out of every given month, there's 2 months in which your client is gone.
2 weeks.
2 weeks, thank you.
Yes.
2 weeks in which your client is gone, and your proposal was child resides with mom during those 2 weeks, child resides with dad during the 2 weeks that dad is not working and is at home.
Correct, but I think that it would have had to have some sort of cap on it because there were times that he was home more than 2 weeks. So the same as it
Right.
had been, there was a cap of 15 days so that it
Okay.
didn't get overly disproportionate in
And
his
the
favor.
trial court's reason for not doing that was because,
His employment schedule created this alternating time periods where it was.
because you couldn't set it definitively because it varied?
It was that it varied, but also it was going to have to remain so flexible because his schedule alternated, I think, in 2 to 3 month increments. He got a schedule in advance, but it wasn't always the same. So they would know for a block of time what the schedule would be, but then when that block passed, it would be a new block, and everybody would have to alternate accordingly.
And your argument is that the judge should have allowed the parties the flexibility to work around the scheduling alterations while maximizing each parent's time, as opposed to setting a rigid schedule that doesn't vary based on dad's work.
Correct. And
Okay.
it's kind of a twofold problem. One is that the schedule that the judge did create with this alternating weekends is illogical. It's never going to work. He works in 2-week increments. So if you do every other weekend, he's absolutely never going to be able to do one of those weekends. And then you leave it at the discretion of the wife to then determine when he gets a makeup weekend. And if that never works, then he just loses the time, or he's constantly in court trying to figure out when he gets to makeup time.
Well, was part of the problem the fact that he was living at the homestead and she'd moved back to Morristown?
It was definitely part of the problem.
And that's her problem. Why?
It's not. It's that the problem wasn't in existence until she moved, and that when they lived in the same
Well, I
town.
understand, but did they live in Morristown longer than they lived in this, your client's dream property?
They may have.
I
but-
think they did from the record.
But at the time that she lived in Morristown, she's renting. He owned something. He'd have to sell something to move to where she is, where they had
She's
moved
got to
from.
live somewhere, doesn't she?
I agree she has to live somewhere.
She was going to be renting wherever
Right.
she was, right?
It's sort of my point, is that she could have rented somewhere closer, even if it was halfway. It wouldn't have created this
And
inability.
her job was,
I'm sorry, what?
where was her job?
Her job was in Morristown, but it was in Morristown when she lived in New Tazewell.
Uh-huh.
She got that job after they moved to New Tazewell.
Okay,
She obtained
so
employment.
your client, nothing would change as to him as far as his work or where he lived? And
His-
under your proposal?
Yeah, his employment would stay the same.
And where he lived?
And where he lived, yes.
And his ex-wife, the mother, would have to move back.
Or closer, or he was willing to be the
Well, she wasn't
primary
gonna move back to
caregiver.
the homestead, so yeah, she
Right.
moved back closer to where.
Right.
Even though her job was in Morristown.
Right, and even if it was something halfway where she could still get to where she was going.
Could he sell and move halfway?
He could. They both could have
Could he
moved
move
halfway.
Could he move to Morristown?
They both could have moved.
All
Either
right,
one
all
of them
right.
could have moved.
Just as easily, it was just as easy for either one of them.
It was not just as easy for father because he would have had to sell, whereas she was renting and could obtain rental without having to sell. But either one of them could have moved.
Okay.
But the other part of it is that the father had indicated that the home that he'd been living in with the child is somewhere where they had bought it specifically for the properties of having that hobby where they were enjoying that together, and he wanted to maintain that particular stability he had purchased and procured while in the marriage. He wanted to maintain that for the child. In addition, with this, the schedule, with it being rigid, so in that case, Maddox P. from the brief, that was the situation where she had sought a modification after a trial court had given flexibility. She wanted a modification seeking to make that schedule more rigid. However, in this case, there was a temporary parenting plan that basically had 50-50, and then throughout the entire trial, she was seeking to make it more rigid. Then when it was made more rigid, it became like maximum rigid, because even in the crafting of it, with it being every other weekend, it was impossible for him to maximize time on a schedule where he's, by testimony throughout the trial, obviously going to miss one of the 2 weekends because he's consecutively away 2 weekends in a row. So with it being illogical, I would ask this court to find that it was an abuse of discretion, allow us to reverse it, and allow an opportunity to have it where this was a plan was crafted that was more equitable between the parties, maximizing both parents' co-parenting time, not seeking to take it away from her, but to maximize both parents. And then the other part of it is that in that change that the court made at the end, throughout the whole time that the parties had been in this interim period prior to trial, they had had not only an equal co-parenting schedule, but also shared decision-making authority that, frankly, wife wasn't doing because she was making unilateral decisions. If they couldn't agree, she'd just unilaterally make the decision, and if any other decision was going to get made, they had to litigate it. And so part of that was that she wouldn't connect with him. She wouldn't take his input into any decision. It was what she wanted, and it always further immersed the child further away from him and made it such that it was impacting his time. He was trying to get as much of that 50%, not because, like in some cases where the fathers or parent who's paying support might have been doing it because they're just trying to put days in their chart just to minimize their support obligation. This is a father who, by all the record and the transcript would reveal, is a very invested father who just wanted to spend as much time as he could with his child the way he had when they were together. And the court the statute trying to maximize time, and the case law really would emphasize that there is a presumption that you should try to maximize that time to the extent that it makes sense for the child's well-being. And in this case, this child's very bonded to her father by everyone's testimony. A good father who just wanted to be a good father, take care of his child, and child was very bonded to both of her parents.
Is this the only issue that's been presented, the child care, child custody,
The parenting plan.
visitation?
No, Your Honor. It's certainly the more dominant for the father for that issue because he's so invested, but also as to the impartiality that was occurring during the trial. There was a lot of concern that sort of culminated over the course, a little bit at a time, until the very end. It wasn't really evident exactly how impartial it was, but it was just the way in which the trial was conducted. It created an environment where there was not an opportunity for counsel and the father to really present his case in a way that might have made a more clear record and an ability to present to the trial court, but ultimately to this court perhaps, of the propriety of the proposal he was making regarding co-parenting time.
Okay.
And that there was a multitude of instances showing that there was a large amount of testifying from the court, as well as taking into account personal knowledge and opinions, giving a nod to the other side about what would make a difference into how a decision was crafted, advisory opinions, things like that, that just made a difference into ultimately whether or not the father was allowed to have this fair and impartial trial as is permitted by the rules.
One question on that.
Yes, Your Honor.
On the personal knowledge of the court that you're
Yes.
talking about, I assume you're talking about the fact that the land of your client is located close to one of the trial judge's relatives, correct?
It's his relative, yes.
Yeah. And I think he told
He
both
did.
sides about that to start with, didn't he?
He did, Your Honor. And at the time that was disclosed, I think they all took that to mean that would probably be fine. I mean, he's...
Nobody objected to it.
No,
either
in
side.
fact, they specifically indicated that they were not objecting to it. It wasn't till later on, as the property was coming up, that the judge was inserting more knowledge that was about the property that was not available in the testimony, was not available in the appraisals, was not available anywhere else, except for Your Honor's knowledge regarding his growing up around that property and it being, I guess, part of his family for some period of time.
Did you give any specific example of how the trial court having this knowledge harmed your client?
Yes, Your Honor. With this, the valuation of the property was a real struggle because I think that Your Honor's knowledge about the property constantly had him questioning the value of the property, and despite having 3 appraisals and expert testimony regarding the value of the home ranging wildly between the 2 values, or 3 values really, and it made the court make the decision not to not make the decision. Instead, putting significant pressure it seemed like for a multitude of reasons, largely because throughout the trial the court had been indicating that he really was encouraging and wanting to father to sell that home and move. Sell it because it didn't make sense to have it. Sell it because that house couldn't possibly be worth what these things say it should. Move because you need to be in Morristown where the child is.
Well,
move.
Didn't that occur in the time when the trial court was asking your client what he was going to do if he had the child and gone for 2 weeks, and your client's answer was that I would hire somebody to stay with the child for 2 weeks?
Now, if the wife could not take care.
No, that wasn't what his answer was. That wasn't what he said, was it?
It is what he said. He did first come out with that he wanted the wife to have the time, but if she couldn't have the time, he would hire someone.
He did at a different spot say, yes, he would want to have those. And the trial judge was questioning about whether or not what your client wanted was the mother to move back, not to live with him, but move back into the general area.
Because he wanted her to have that time.
Was the answer to the question yes?
Yes, the answer to the question is yes.
And did the trial judge ask him why he couldn't just as easily move to Morristown?
He did.
And did the trial judge say, I can't make either one of you move?
He did.
Okay.
He did say that.
So the trial judge was left with, Dad says I'm staying here, Mom says I'm staying here, and the trial judge has no power to make them move, either one of them.
That's correct.
Okay, thank you. You have your time for rebuttal.
Thank you, Your Honor.
We'll hear from the appellee.
Yes, good afternoon. May it please the court. I'm Aaron Chapman of the Hamlin County Bar, and I'm happy to be here, and thank everyone for being here, and I thank you, Professor Hilton, for being here as well. We've spent a lot of time today discussing the parameters of the parenting plan that was ultimately entered by the court. As this court is obviously well aware by now, we've challenged that sentiment, mainly on the basis that that parenting plan was a consent decree. What was entered in March of 2024 was entered by agreement to the parties to resolve the pending challenges to the verbiage of 3 specific sentences that father had attacked in the 2023 parenting plan. And so
You say it's a consent decree?
we believe it is. We believe it was met with the mutual assent of both parties. Both parties signed it under oath that it was in the best interest of the children. It resolved their dispute that they were having at the post-trial hearing.
Isn't it husband's position that, I agreed to the order because that's what the trial judge had said?
He has that position, but he also has the position that we included other things that help husband out. And so you'll see in the order that went along with that parenting plan, husband says that we entered other agreed amendments that we can presume benefited both parties. There was a bargain there. There was a dropping of a contempt. I don't know that hearing would have ever been brought to the court had we not filed for contempt and got to working that day.
Had the trial court decided and told the parties what it was going to do as far as child custody?
The court had already entered a parenting plan, and so the husband...
Before the decree was entered?
Yeah. Before the March 2024 order was entered. See, we have a final judgment with all issues in May of 2023. What was left over were alimony issues and parenting plan cleanup. In fact, the court ordered as early as January of 2023 what it was going to do as far as child custody. It applied the factors of 36-6106 therein from the bench. I believe if you consult the record, you'll see. And so, what we have is a ruling in January 2023 that affords what the custody breakdown is going to look like. Then we go into April of 2023, and we have an order prepared by Father's then counsel that's an order of divorce meant to document the terms that were announced. See, the January 2023 setting involved a lot of agreements as well. I mean, nearly every property issue that's been assailed on this appeal was resolved via an agreement, and so including the value of the property. So that's important to point out here, which confounds us as to why that's an issue that the judge had made mention that he was familiar with the lay of the land out there. That's not a big deal, because if you read into the record, you'll see that the judge was kind of blown away at these higher appraisals. So I don't know what that issue is. We ultimately ended up agreeing that the property is worth probably more than the court might have valued it. So that issue is just largely without merit. But nonetheless,
Am I wrong? I don't think there's an issue about the property division, is there?
yes. The husband has asked for a new trial on the basis that he was unfairly treated, that the property division was not appropriate, that the debt division was not appropriate when stacked up next to the property division. He's attacked nearly everything in this case, Your Honor. I'm sorry to say, but that's where we are. We have a final judgment in May of 2023, certified as final, no just reason for delay, twice printed on that judgment in May. That's an amended judgment. That amends the April 2023 divorce decree that his lawyer had prepared and lodged with a certificate of service. Both parties consented to the May 2023 divorce judgment. In that judgment, the court states what a parenting plan is going to look like, and that we're coming back for another hearing to firm it up if we can't get that by agreement. I think the court was novel and laudable in hoping that everyone would just agree to work things out, but that was not the basis of trial litigation. So we came back for a hearing that day. I believe the day, May 22nd, 2023, is the day that judgment was entered, but that was also the day that the parenting plan was finally addressed. Then I've been representing the wife for nearly 5 years now. I was involved at every stage of this. I prepared the judgment because we couldn't get an agreement as to the breakdown of what the parenting plan would look like. So I lodged it with a certificate of service at that point. The judge entered that in June of 2023. Then that was attacked by a motion in three provisions of that were attacked. Number one, a pickup and drop-off time. Husband wanted that to be 7:30 p.m. instead of 3 p.m. Number two would be a provision, as we've already discussed, as to who would care for the child when father was absent on his flight schedule. And number three was a lateness provision, because the parties were meeting in Granger County, halfway between their residences. So if father was to be late, we had a lateness provision in there that was attacked. So those were taken up by husband in his summer 2023 motion to alter or amend. And then that stayed open. That stayed open for several months. Then in September of 2023, I think he what I'd call a re-up motion. He files a motion saying that he's waiting on court records, but he wants to stay the applicability of that parenting plan. He wants to stop that from being in effect. No actions taken on that. No hearing is set that I can recall or glean from looking back at the record. And ultimately, it took us filing for contempt over some financial issues with that judgment to actually bring this thing back before the trial court in March of 2024. At the March 2024 setting, we negotiated. We negotiated a parenting plan and sit there with thumb drives and laptops and everything to work out what these parties needed out of a parenting plan, based not only on what the court had ruled, but what also they'd like to include in there. So we added things. We took things down. We reduced child support. So these things occurred, and we entered into an agreeable parenting plan. So that's a long way to answer that question, but I believe that's what led to this being seen and unassailable as a consent decree. And we do not believe that the appeal is justiciable at all with respect to anything with respect to this parenting plan. That's entered by agreement. So, but getting back to some of those issues that we see as dispositive is we don't see this as a timely appeal. We think that the final judgment of divorce and substantive issues were resolved by final judgment entered May 22nd, 2023, which was certified as final, expressly determined that there was no just reason for delay with respect to its provisions, and was agreed to. The form, at least, you don't have to like it. You don't have to like what's in an agreement, but the attorney signed off that was an agreeable form for the final judgment.
Attorneys sign off all the time, don't they, on orders? You know,
Right, I'm not saying it's agreed.
you're reflecting what the judge did.
Exactly, and it's a courtesy.
That doesn't mean that it's an agreed order.
Absolutely. And so we believe that as well, because at this point we'd been litigating, and I think that he did not, I think the husband did not like everything that happened. The wife didn't like everything that happened either, but I was constrained to prepare the ruling. So that's what we did. But we don't think we have a final. We think we have a final order as of that day. Excuse me. We think we have a final order as of May 22nd, 2023, with a notice of appeal in March of 2024, following again what I'll call a conference where we appear before the judge to argue a contempt proceeding, and yet the parties sit down and negotiated an agreed parenting plan format that was lodged. So that's the procedural history there, and you'll see that we began to argue before the record was back and before briefing had started. I believe we began to argue that this was an unappealable case, or at least unjusticiable, based on that 2023 finality and that 2024 agreement being reached. And so we were told to take that up in our brief, and that's what we did. We've asked for attorney's fees and a finding of a frivolous appeal on that basis. Nonetheless, going back in, I have about 5 minutes left, so nonetheless, going back into the issues that were brought up by the husband on appeal. Husband is attacked today, and in his initial brief, he attacks the fairness and impartiality of the court. I think we've talked about the property valuation and how that would have had no merit because, number one, his values that the court was kind of spitballing around, or his attitude that he was kind of spitballing around, seemed to be more favorable to husband's end of it. See, husband had an interest in bringing the value down, and wife had an interest in saying that the property was worth more because husband was going to stay there, so she was going to have to be bought out. So, husband's saying, I'm not quoting or mocking or anything, but saying, dadgum, I just don't see that property being worth what you all see it. This blows my mind. This is just, utterly confounding. Whatever he wants to say in his, dicta to the parties, that just indicates that he's surprised that it's valued as high as it is. And then husband and wife agree that it is valued higher. So that's, we don't see that as being meritorious. Also, with the fairness and impartiality side, husband complains he was questioned by the trial court. He says nearly 200 pages or something of the transcript. I think we appeared 4 or 5 trial days, so you have to take that into context. But he was questioned, but his inability to prepare for that, be ready for that, that's not the court's problem at this point. And all of that, again, a lot of that, no, I won't say all of that, a lot of that involved things that were ultimately resolved by announced agreement. And so the structure of the trial was somewhat anomalous, that because we would have an argument over something, and the court would come out and say, well, I've got the right to sell that property. And then we'd get 15 minutes or 30 minutes or whatever and come back in and say, what's going on? Are we moving on? And we say, oh, we have an agreement. And so you can see that in the record for sure. But we think that any concerns with fairness and impartiality needed to be addressed with a motion for recusal, and a timely one. And so you can see some of the authority that we've cited says, well, to wait till your brief is due in the Court of Appeals to begin to attack the impartiality of the court is not proper. And we've cited authority all the way up to a capital murder trial where the judge took over questioning a witness, and it was not found to be reason to overturn the underlying trial. And that's a much higher standard. So I think the other issues involve the parenting plan. We've talked about that. I think the courts have hit on some salient points. Importantly, note with the father's schedule, this was not he's gone 2 weeks, he's back 2 weeks, he's gone 2 weeks, he's back 2 weeks. It's he's gone 3 days, he's back 4 days, he's gone 6 days, he's back 10 days, he's gone 14 days, but 2 of them are marked as medical days off, and he's to report to another location to receive medical testing as a pilot. So they're not flight days, but he's around, but those are marked, and he calls those days off, I think, at times. Things like this. If you look at that schedule, and it is of record now. I mean, if you look at what his flight schedules were, it was insane to expect that we would just work around his days off. I will note that the case was filed, the child was 3 years old, and at that point, there was an argument whether or not, early on in the case, you can see there was an argument about whether or not the child's in preschool, or whether we're calling her preschool program a daycare program, or whatever it might be, but you're seeing a much younger child. But time soldiered on, as this court likes to say in other opinions. We got to the point where we're dealing with a 6-year-old child and a 7-year-old child, by the time final parenting plan was reached and entered. So those earlier issues, that this case lingered on so long that child, we lost the time in which to argue over what proper child care was. And the court entered a temporary parenting plan that was equitable and in the child's best interest with respect to that time. So we do not agree with opposing counsel's recitation of the facts that it was a struggle to get this child. I mean, we were within a month or two of this child moving from Morristown. The mother moving. She did not leave in the middle of the night or anything. I think that's in the record, saying how that went on. We had a temporary parenting plan, and we went back and modified, and we had to take the father back to get the child to school and things like that, and you'll see all that. So I feel like the parenting plan properly weighs all the relevant factors. It's not an abuse of discretion. It's not been shown by the father as to why that would be an abuse of discretion to follow that parenting plan. Not touched on alimony today, but again, not shown to be an abuse of discretion as to why that $28,800 alimony in Salido award should be overturned. We feel like that the court properly analyzed those factors. And quite bizarrely, I think you also see in Father's brief, he spends an inordinate amount of time in that brief attacking the court for not allowing proof on an idea that he might move to Morristown someday. And so he comes out and files after January 2023, it files a motion to reopen proof saying he's thinking about moving to Morristown. So we need to have a new custody trial. And the court just, whatever you want to call it, slaps it off the bench. There was nothing before the court, and he ultimately did not move. And so all these things point to that this appeal is really frivolous. We have a final judgment as of May of 2023. The things that were reserved were not addressed in the motions of the summer of 2023, except for the parenting plan, which itself was resolved with an agreeable document, which, again, Father says, reflect the court's rulings, but also include some agreed amendments. We think that destroys the justiciability of complaining over that parenting plan, and that's what I have. Thank you.
We'll hear from the appellant rebuttal.
Yes, Your Honors, thank you. As to the finality of the order, it's clear and replete within the law that a final judgment's not final until it resolves all outstanding issues. And if you have some cleanup that needs to be done in subsequent hearings, it couldn't possibly be final, particularly because the order specifically that he's speaking of didn't even have a child support worksheet, which is one of the clear reasons in which an order would not be final if it did not include a child support worksheet and a child support finding. And so that was ultimately resolved in the March 2024 order when the parties did sit down and come up with it, but there's a notation within the order itself that says this was to conform with the rulings of the court. There were some things specifically that the court had not addressed at all, and some of that was...
Well, in fact, the trial court talked about it without a presumption of correctness due to the pendency of a permanent parenting plan order.
I'm sorry, what?
I mean, that was in the trial court's order. It said, here's the temporary support, which is entered without a presumption of correctness due to the pendency of a permanent parenting plan order. Now,
Right.
what the trial court itself
Recognized.
stated, that we're waiting, we still have to do a permanent parenting plan order.
Yes, Your Honor. And when the parenting plan that was submitted that was to supplement that and be final and got signed, we filed the objection because we had not had an opportunity to, or we did not agree and sign off on it, and so they're filed for an amendment to have that altered and ultimately at the final hearing to come up with those things that we could that would conform as closely as possible to what the court had ordered, but had not otherwise been specifically addressed. Things such as pickup and drop-offs and certain holidays that had not been addressed within the trial court's ruling, but still to conform. I don't think there's any question that at no point throughout this trial did the father ever say, I'm okay with this every other weekend business in the summer. He was very clear throughout that he thought he should be primary or he should be 50-50, but he did not at any point say that he thought that the overall ruling was correct and that that final order that we entered as a parenting plan, despite the fact that it was in the Tennessee Supreme Court's form, the permanent parenting plan form, it says on it, or it's missing the language that would have said at the top, proposed, agreed, or ordered. It doesn't have that. It doesn't have any demarcation for that, but it does say that it was being entered to conform with the rulings of the court. And then, and so I would say, and certainly have filed an appeal based on the final order being that order in March of 2024, and that this is a justiciable appeal, that the issues that were raised were issues that have legal and factual support and certainly not frivolous, and that we have sought to have an equitable co-parenting plan and equitable distribution such that it would be in conformance with law and would be in conformance with the statute on those subjects. Thank you, Your Honors.
Thank you. We thank both sides for your oral argument today and your briefs on this. If you would please adjourn court until tomorrow morning at 9:30.
All rise. This honorable court of Tennessee stands adjourned until 9:30 tomorrow.
Thank you. And we'll hang around for the class. Y'all are welcome to stay. They may want to ask you all questions.